que están en la parte de abajo de su pantalla y elija español. Si tienen una tablet o un celular, hagan clic en los tres puntitos en la esquina inferior derecha de su ventana Zoom, luego en interpretación de idioma y después español. Si no selecciona idioma, no podrá escuchar al intérprete cuando hable en su lengua. Muchas gracias.
Thank you very much, Christian. Thank you, Sarah, for your coordination, the Justice Center for being behind the scenes. And thank you to everyone that has spent not just today, not just this week or this summer or this year, but has spent decades against really honoring a constitutional mandate for access. This hearing that we just witnessed by the North Carolina State Supreme Court is the beginning of oral arguments on whether or not they should transfer $785 million of $6 billion plus of an investment into underfunded public schools in low performing or high minority communities. We have with us several different individuals that have been leading this work, and I'm excited to toss the conversation over to them. Before I do that though, I want to introduce each and every single one of them. First, we have David Hinojosa, attorney with the Lawyers Committee for Civil Rights under the law. We have President Corine Mack with the Charlotte Mecklenburg NAACP. We also have President Gerald Givens with the Wake County NAACP, both of which are executive leaders for the North Carolina State Conference. We would ask that all participants please mute yourself until we have the question and answer period. And for all media, if you could please identify yourself whenever you're asking your question in the chat or whenever you're asking your question at the appropriate time. So at this time, I want to toss it directly to the individuals that were in the room. I want to start first with David. Give us a rundown or a summary of what we experienced today in the beginning of these oral arguments.
So the legislative interveners, the defendant interveners, Speaker Moore and Senator Berger, stuck to their game plan, which was deny that there was ever a statewide violation of the right to a sound basic education, deny that they played any role in that statewide violation, and deny that the state courts themselves can do nothing to stop the legislature from denying the right to a sound basic education for all children. In spite of, as plaintiff's counsel referenced, in spite of over 400,000 students not even meeting minimum proficiency standards in the state of North Carolina, they've done virtually nothing to address, these stark findings over the past 2 decades. So that was their primary game plan. There was a lot less discussion about whether or not the court itself can order a transfer, because that's the big thing. You mentioned, the 700 million plus, that's still outstanding to be funded in the comprehensive remedial plan. That includes funding for students with disabilities, funding for low-income students, funding for English learners. So the students who are being challenged the most in the state, and who frankly don't have generations of wealth to fall back on, are the ones who have been neglected by the state. And whether or not a court, the biggest question, aside from not whether or not there was a statewide violation, because as plaintiff's counsel and the state of North Carolina proved through their arguments, there has been several findings over the last 20 years on the state's failure, the statewide failure. So it wasn't just about Hope County, it was about much more. And the biggest question is whether or not a state has the judicial power to order the transfer, because ordinarily transfers from the state treasury are from the legislature, but the legislature has balked. It has not wanted to transfer those funds. So a court said, okay, I'm gonna give you a chance, I'm gonna give you another chance, I'm gonna give you another chance to fix this. And it never did. And so the court had to step in and order the transfer. And now the court will answer the question whether or not there is that judicial authority to order that transfer.
David, is this situation, and you've been in the court of law for numerous years and seen numerous cases. If this were a case of someone owing, one party owing another party, plain and simple, that was not the state, what remedies would the court have to get those funds that were demanded in court?
So oddly enough, ordinarily a court may not have the authority. So a court can order someone to pay, right? You owe a money judgment of $1 million. The court can order someone to pay that. And if they don't, then they can go and possibly, put a levy on, certain non-residential, property, for example, and they could try to execute eventually, a warrant to try and collect those and then sell them so you can try and get, some funds. With a state entity, though, ordinarily you can't do that. But what we're arguing here is it's not just about money. It's about a sound basic education. A sound basic education does cost money. All those programs and services, improving teacher retention, improving principal quality, expanding pre-K for all at-risk students and improving that. All these critical supports, most of them unfortunately cost money. And so we need those funds to pay. So what we're arguing is this isn't no ordinary money judgment. They're trying to argue on the other side, just give them a money judgment for 800 million and good luck on collecting it, because you're not going to be able to collect it against the state itself. If it was against a private individual, then maybe you could, go. But here, because there's a denial of a state value, a sound basic education, and the only way to fix that we know of is through the comprehensive remedial plan, and that comprehensive remedial plan has to be fully funded to be fully implemented. And so that's at its core, that's what we're hoping the court will do.
In previous argument on this case, it was stated exactly so. If the writers of the Constitution, they understood fully the financial obligation, which is why they put the right to a sound basic education in the Constitution, so those resources of the state can provide for this constitutional mandate, which makes this conversation today around the 785 million, which is a fraction, 13% of the totality of the West Ebb report. It should really be a given, but for some reason, the North Carolina General Assembly has denied responsibility. Now, I want to hear from Minister Mack and from both of our presidents here. What was it like being in the courtroom today? And I know you've been a part of the case for several different years, Minister Mack, as a plaintiff in the second iteration of Leandro. What was the feeling being there today?
There was a level of frustration, clearly. Initially, when I heard the attorneys for the controller and for the state legislators begin to speak, I went into prayer. To be frank with you, I closed my eyes and started praying. But I was already expecting the level of disrespect and disregard for our children today, because I've seen it so often prior to today. But what I must say is this: I was always hopeful that these adults will understand their responsibility, their God responsibility, but more importantly, their legislative responsibility to ensure that every child gets an equitable education. And to be reminded that our children, all children, are our greatest commodity. I did not see that, and that was deeply disturbing for me. Coming to full revelation that there is a level of disregard in this country and how far we've come away from our true humanity. But I'm still hopeful. And I have to say now that I really thank God for the state and how they represented us today.
You mentioned something about hope, and that's been the theme today. It's been the theme this whole time, hope that the state will live up to its Constitution. And I think that's very interesting. Judge Newby seemed to be very interested in the origin story of this case. And you mentioned that, David, but Minister Mack, was it obvious that it seemed to be from just that one particular question and answer period that he was trying to narrowly create a situation where only one county is harmed or has been harmed in this process? Did that come across as obvious as it did for those of us that were listening or watching remotely?
Listen, Stevie Wonder and Ray Charles could have seen this, right? I mean, it's just what it was. And it goes to the fact that there's so much bias in the system right now, right? We believe that the judicial system has a responsibility to be unbiased. I also believe that it should be nonpartisan. I think the partisanship and the whole team and tribalism that's happening right now is damaging to their constitutional beliefs and our constitutional beliefs. But yet again, we've seen it so often, we have to expect it and still be hopeful. He clearly was trying to say that Hope County was the only problem, when it's very simple. We can see that throughout the state of North Carolina and every educational system throughout the state of North Carolina, children of color, those who may have disabilities, those who may have language barriers, children who have additional traumas and personal and home harms are the first children to be harmed because of the way the system is set up. And we have to be intentional about the fact that we know that from the inception of the education system, Black children and children of color have always been left behind. So this is not new. What we're trying to do now is find ways to ensure that from this day forward, all children have an equitable opportunity for good education and good quality education. That's the whole purpose of this.
That's a very good point. I want to turn it to Wake County NAACP President Gibbons. Being in Wake County, one of the above wealth areas in regards to funding for education, there's still pockets of Wake County that are seeing the quality of education unequal across the district. Maybe not as much as some of our rural areas, but as we're listening to the arguments today, are we hearing from the court, or did you hear from the court an emphasis on low wealth communities and serving those with a sound basic education? Did it seem as if they understood this investment of $785 million is going to go not just to one demographic of students, but to students that are English language learners, students that are have different abilities in school? Did it come across that they really understood the totality of this situation? Or do you think, as Minister Mack was saying, they were trying to marginalize or limit the argument for funding?
In our country, we are culturally conditioned to undervalue, underestimate, and to marginalize people of color. And here in Wake County, in the NAACP, we receive those phone calls from parents who are trying to get the best education for their kids, and they might want to transfer a kid to another school, and then that school that they transfer them to doesn't have the same services that they had from the previous school that they went to, and then that kid falls behind. And to me, that's a very touching subject, because my daughter just graduated from one of the top engineering schools in the world. And when she was in first grade, her teacher decided that, thought that my daughter had some type of issues or some type of problems. And so when we sat down with all of the top experts at the schools, I said, test my daughter for everything right now, because we want to know what's wrong now. They fixed it in first grade. She ended up graduating from high school a year early. And then now she just graduated from one of the top engineering schools in the world. We have to give an opportunity for our education system to succeed for every single child in North Carolina. When I sat there in my seat today, out the corner of my eye, I could see that American flag and a POW flag up in the air. You can't get an opportunity to become a POW if you can't read. And when we heard that there were 400,000 children, 300,000 children being denied the opportunity to read at grade level, that should have pricked the conscience of every single one of those justices in those black robes, not a red robe, not a blue robe, but a black robe, sitting right in front of those scales. with two even scales, not a red scale, not a blue scale, an even scale, because that's what this is all about, justice.
I want to toss it back to David. We could see a lot virtually, and I know for a fact that there was a lot of energy in the room. What could we not see from the arguments? If I'm not an attorney, if I'm just a passionate advocate for education and I'm listening to these arguments, number one, I think there could be some differences in really recognizing what is at stake, what are we asking for? But could you tell us a little bit more about the things, the elements of the oral arguments today that may have been hidden to just a everyday person having to be flipping the channels or just catching it today?
Yeah, you know, most of the argument was dominated on whether or not there was a statewide violation, right? To us, that's always been a red herring. There's substantial evidence in the record that Ms. Dubis, for the plaintiff's attorney, had alluded to very effectively, I thought, you know, throughout the duration of this lawsuit. But there was so much focus on that. I think we lost sight of, you know, the biggest question on whether or not there's judicial authority to order transfer. And it wasn't until Justice Morgan, with, I think there was maybe like 7 or 9 minutes left in Ms. Dubis's argument, where he finally brought up that question. You know, a lot of the briefing from the plaintiffs and plaintiff interveners was, you know, centered on that. You know, yes, the court does have the authority to issue this provision because the state can't use the appropriations clause, the clause that says, you know, that appropriations must be made by law. They've always interpreted that to mean, you know, that it has to be a law enacted by the legislature. But the Constitution itself is a law, right? I mean, consider, you know, a law, the supreme law of North Carolina. And for them to suggest that, yeah, we can have a general and uniform clause that requires a sound basic education. Yes, the state has the duty to carry that out, but the courts can't make them. When the court's main duty is to administer justice to those harmed, absolutely. Where does that leave, you know, the school children? And I think that the fact that that was not picked up until the very tail end of the law, the fact that the defendant interveners did not really talk much about that because they were trying to deflect the attention away from the court. They were trying to distract the attention. That's been their main ploy. You know, our clients, our friends, you know, Charlotte Mecklenburg, just last Tuesday, the state moved to dismiss their appeal. And the state moved to dismiss all the briefs that we had submitted, over 200 pages of arguments of briefs, because the legislative interveners claimed that they had no interest in a statewide remedy, that their only qualms were with Charlotte Mecklenburg schools. Yes, they have major issues with Charlotte Mecklenburg schools, but for the last 4 years, they've been very involved in the development and passage of the comprehensive remedial plan. Sorry, haven't had much sleep over these last couple of weeks, a couple of months for that matter. But, you know, and so it was, you know, these efforts to try and distract the court's attention away from some of these issues. And yet again, they were trying to distract the court's attention and just try to focus zero on, or focus the court's attention on, there was no statewide violation. There was no statewide violation. There is no order. And there's lots of orders, you know, including, you know, orders from 2020, 21. And so I think, you know, it's important for people to understand that, you know, this whole argument about whether or not there's a statewide violation, that should be pretty easily answered, even though there wasn't always, you know, that clarity, you know, from the parties arguing it. But the big seminal question for the court will be whether or not there is, whether or not the transfer provisions are lawful.
Now, tell me this, David, and I may be incorrect. Has the General Assembly ever formally challenged the ruling from Leandro?
No. Matter of fact, they've sat their behinds. It's some self-editing. But they've sat on the sidelines for the last 9 years or prior to 2021. So In 2013, they passed the law, as many of you know, that allowed the legislators, the speaker and the Senate president, to intervene into challenges to laws, challenge the constitutionality. They wanted to open that door. Well, where were they in 2015 when Judge Manning issued his order saying there's a continuing violation? Where were they in 2018 when Judge Lee came out to the case? And as Ms. Dubus pointed out, that large Redwell folder of evidence that was presented by the state itself saying we've satisfied our obligation, and the court finding, no, you haven't. Now we're going to have to, I want you all to enact or propose a comprehensive remedial plan. So where were they? Where were they in 2020 after that comprehensive remedial plan was being developed, after a huge study had taken place? Where were they in 2021 when a consent order was finally ordered to put the comprehensive remedial plan into place? Time and time again, they didn't do anything. They sat on their butts, hoping to get away with as much as they could and putting as little effort into education. Our Constitution says otherwise. And I think that ultimately, the court's going to struggle a little bit, with this decision, because you don't typically have this problem, right? I've litigated in Texas 2 times over. It has not taken 17 years for a legislature to respond. Sometimes they respond, in piecemeal, and you have to urge them and re-urge them, to do it. But even in Texas's, history, it took them 6 years to resolve the constitutional violation.
So our North Carolina General Assembly is less progressive than a Texas State General Assembly.
Well, I don't know about progressive, but they're definitely more responsive than North Carolina has been over any other state. And I know most of the state decisions across this country, from Kansas to Washington State to New Mexico, all these states where they've held, these violations and ordered the state to fix it, they've ordinarily fixed it. It might not be perfect fix sometimes, but here we just had no fix, from the legislature.
So let's get this clear. The General Assembly, who is charged with providing based on the Constitution and has been found in neglect of meeting that resource mandate, has never formally challenged the ruling, but still the arguments that they're making seem to come up in conversation today. How is it that you think we can get to this point where the court has already demanded in several different instances on several different levels of remedy, and instead of the General Assembly actually standing on whatever positive or negative they have done, the courts are still having to kind of argue with almost an empty chair?
Well, they're trying to do this by recreating the record, right? They haven't been at all these, again, they had suggested that Charlotte Mecklenburg branch of the NAACP had been absent from the statewide proceedings. Look in the record, you can see their name as the pen interveners, participating throughout this. Judge Lee invited them to participate, and they were very active in ensuring the protection of at-risk students, especially, their right to a sound basic education. So, no matter what the state legislators are saying, I mean, it's like this, whole thing about stealing the election, right? From the Trumpers. Steal the election, steal the election, steal the election. They stole the election, they stole the election. Keep on saying it and people are going to start believing it. They're the ones saying there is no statewide violation. There is no statewide violation. There has been no statewide violation. There is no evidence of a statewide violation. But the justices should be smart enough. They will be smart enough. At least the majority of them will be smart enough to look into that record and see otherwise. So it doesn't matter, that they've been absent, all of these years and now are coming in to try and recreate the record, because the record's already been written. So they can argue what they want in their briefs, but the bottom line is that record sticks, and that's accurate and factual. And that shows an incredible legacy of neglect on behalf of the state, especially for at-risk students.
Marcus, he said the word record earlier, I think it was last week. Dave sent over a message, hey, I need you guys to go down to Wake County Clerk's office and go find this particular file for us. And so our legal redress team chair and I, we went down there to the clerk's office, and these hands touched the very first documents from like 1993, 94 that were there. And the volume is extensive. I think there was like 6 or 7 cases of records dealing with this case. And imagine arguing with somebody for 30 years in a conversation about taking care of children. That's what this is really about. And I think that that's what we have to continue to try to get the justices to focus on and the legislators to focus on. It's the children who are the ones that are being the most impacted by their decisions and lack of decisions.
But think about this. You saw cases and cases on this particular case back to 1993, 1994. Think about every child from that time to this time.
Yeah.
Who didn't get an equitable education. And where that child may have ended up.
Yeah.
That's the thing that breaks my heart. That we're talking about human beings, we're talking about children. And no matter how we may feel politically, or what our religious beliefs may be, and even our economic status may be, we're talking about children. And our responsibility as the adults is to ensure that every child gets what they need to be a viable adult at some point in the society, right? And to sit there and have folks who've been elected into a position pretty much gaslight us, right? And continue that negative narrative, that false narrative, that there's no problem. When everyone in the room, including them, knows the facts. We've got to do better in North Carolina. You know, years ago, I think it was about 9 years ago, we had this whole campaign around economic equity, and come to find out that we were 50th in the country for Black urban mobility. North Carolina, Mississippi and Alabama are doing better than North Carolina. And here we are now, seated at a table discussing educational equity. We have to always go back to the beginning. And no matter what anybody feels or thinks, as a Black woman who raised 3 Black children, I knew the importance of pouring into my children. I knew the importance of advocating for my children to ensure that they got everything they needed in the educational system so they could be viable adults and put something positive into society. But every parent may not have that opportunity, because in North Carolina, when we talk about economics and education, they go hand in hand.
Absolutely.
There are parents in this state who are working 2 or 3 jobs just to simply make sure their children can eat and have a roof over their head. They don't have the time that they would love to have to put into that child, which is why this system, the education system, is so important to our children, that we do in fact have good qualified teachers, and that we do have qualified and credentialized principals, and that all our children have the right textbooks. And those children who are in rural areas, in fact, do have broadband. And if they need a tutor, they can, in fact, have a tutor. All of these things are necessary. And it takes funding. And the funding's been sitting there because the individuals who already knew there was a problem made a determination they weren't going to do anything. And here's my question. If, in fact, the court can't make them pay, when will they pay?
Absolutely.
When will they pay? They have no intentions of doing the right thing. So someone has to ensure that that happens, which is why we did what we did, and why all the partners are so engaged in this particular work, because we understand that we've had 18 years, that's now an adult. 18 years ago, it was a child, someone's child, but now we're talking about the same issue that has not been addressed, that has not been resolved, and they are still telling the same false narrative that there's no problem.
it's very possible that the original students that were in school in 1994 now have students that are preparing to head to middle school and high school.
Very possible.
It's not possible. It has happened. There are children in schools who were child plaintiffs, at the time in 1994, and they are now parents of school children. One thing that I want to make clear though is that there's a lot of problems with public education, right? There's a lot of challenges with public education, and the promise of public education still has yet to be realized. This sound basic education, the comprehensive remedial plan, they made a lot of noise about. There's 146 measures here. There's 146 provisions in the comprehensive remedial plan. This comprehensive remedial plan puts in basic foundations, for improving and solidifying, high quality pre-K program, creating pipelines, without holes, in them for, teachers and principals as well, providing this key supports for, at-risk students. But this program, the comprehensive remedial plan, is still a limited plan. It's still quite limited. It doesn't fix everything that's wrong. All it does is provide that minimally necessary sound basic education. It does not provide an excellent education for all children. That's still the legislature's job, but its constitutional duty is to provide that sound basic education, and it has not presented any alternative to the comprehensive remedial plan throughout the history of this case.
And we should be trying to take the lead in being the best at public schools. One of the blessings that I've had in life was being able to live in basically every region of this country by being a veteran. And the one thing I noticed is that in every place that I've lived, the education standards are different. Now, just imagine if trains had different tracks in every state. None of the trains would be able to get anywhere. And that's what we're doing to our children in our country. If you live in Mississippi, Mississippi's about catfish, cotton, and casinos. You go live in the state of Washington, they got Microsoft, Boeing, and all these other great companies. And that's impacting these kids who are not being able to get the resources that they need. And North Carolina needs to step up to the plate. We have the opportunity and the capability right now to make a difference up to the tunes of $7 billion, I believe. And we should be focused on doing the best we can for these kids.
The last question I have, and then we're going to open it up to the audience. And we have a very big audience on Zoom right now. Surprisingly, in the middle of the day, listening to us now, just on the Zoom alone, we have 63 folks, and that's not even including the folks that may be listening in other ways. This notion of picking out Hope County and singling out this conversation, or even the remediation to Hope County, even with 30 years, they have 28 years, they haven't, provided any additional funding to Hope County in this regard. But how can you, or how can the court pair that argument with what the Constitution says is really a uniform system of schools? So if we have a uniform system of schools, but then they're trying to single out Hope County, what do you think the court is trying to do, or what do you think the motive is in trying to narrowly change uniformity in our school system or school districts with this lack of support, or trying to narrowly define the remedy to just one school district?
Well, it's a little outrageous to suggest that, one, the record's clear. It wasn't just about Hope County in the first place. There were plenty of other superintendents from all across the state who testified. I think Ms. Dubus had pointed to the record, or maybe it was the state's attorney pointing to the record, that Charlotte Mecklenburg, educators had testified, and from a number of other states. So that, to suggest that the Leandro ruling itself did have conflicting language around Hope County and the remedy itself, but the record itself, shows, otherwise. But the fact is, what makes it most outrageous for them to suggest that you could just focus on Hope County is that, okay, let's say you fix Hope County, you provide high quality pre-K, you do things to improve, teacher recruitment and retention and principals. Where are they getting those teachers from?
Correct.
The neighboring district. Now what happens to the neighboring district? Neighboring district has to say, hey, they took all our things, all of our teachers and educators. Then people start moving to Hope County because they're like, well, heck, they got better schools there. So now what happens to that county district? That county district has to sue, but that county district was already suffering because we know by the statewide data doesn't lie, right? And that shows incredible deficiencies all across. And it's not just that data doesn't stand alone, that data is connected to the lack of resources and programs that have been shown, throughout the record. But if they want to invite 115 separate trials and 115 separate orders and decisions, that's just outrageous. And that's how and why, the statewide remedy, not only does it fit the record evidence in the case, but it's really the only viable solution to not creating a chaotic an even more chaotic public school system.
I think we have time for some of the questions from our Zoom audience, our online audience. I want to check in with Tim or Matt and see if there's any question in particular we want to have elevated, or even have folks come off mute if designated.
Sarah's in the other room. Depends on how you want to handle the chat. We've got at least 1 or 2 questions in the text chat, and you could also let people come online if you want.
Okay, well, toss us one, Sarah, if you don't mind.
Yeah, I know we have some of our press in the room, so we do want to give this opportunity to some folks to ask some more detailed questions of speakers right now. If you do have a question, if you can raise your hand so I can see you, introduce yourself, where you're coming from, and we just ask that you keep your question rather brief. These good people have had a very long day, so we are going to try and wrap things up by 1. Any questions from folks in the room?
Yeah, when do you think we could expect a decision in the case?
It'll probably take at least a couple of months. Sometimes these decisions can take, 5-6 months. I've waited for, 10 months or 12 months, but I think that, given the extensive briefing schedule, the court is interested in fixing this. I mean, we've had a denial for several decades, or for a couple of decades, actually it's several decades now, because you can put it back to 1994, because what they alleged in 1994, they proved, in the hearings that followed the Leandro one decision. But we are hoping that there can be a decision, within the next 2 to 3 months, so that the legislature, if they need to do something else, or the court needs to hold a hearing to figure out what happened, with the July 2022 budget and how that impacted, but let's get these key legal questions, argued if we, or settled if we can. So,
Since this is centered on years 2 and 3 of the 8-year plan, do you think that we'll get any kind of clarity on how we'll proceed with those remaining years that need to be funded and implemented as well?
well, hopefully, if the transfer orders are put in place and they're upheld, right? If those transfer provisions are upheld, then hopefully that will send a signal to the legislature if they don't want anybody, grabbing the purse strings of the budget and doing this again. They'll do it themselves. They'll take the initiative themselves to fund years 4 and 5 when that comes up in the budget, years 5, 6 and 7 when that comes up in the budget, for the next few years, that come into play. But again, you can never tell with this legislature. They love to not follow the Constitution, whether it's on voting or education and many other matters.
And one of the questions in the chat it's probably, everybody could probably chime in on this, was what exactly are we saying kids are at risk of?
Well, I can tell you that there's several areas of at risk for children. First of all, the level of suspension. Right? The fact that many Black and brown children are at risk of being part of a system, the incarceration system, and having high recidivism due to lack of education. They're at risk of never, ever really getting an opportunity to economic equity. And what we don't deal with is the actual trauma that these children are going through. There's a portion of children who are in the education system right now who are actually without permanent shelter. Their families don't have permanent shelter. And that's not being addressed. So being in that situation causes an additional domino effect of risk. But the largest risk is the psychological and emotional harm that's being done to these children that has not been addressed and will not be addressed. And while I'm speaking, what I really want to talk about before I forget, because I have senior moments, is that we are in an election year this year. And how we go and vote, and because we go and vote, can change the entire trajectory of the state legislation. And people have to know that. If you're not doing anything else around this particular work, you can go and vote to ensure that we have legislators who care about our children.
Absolutely.
And state Supreme Court justice.
Absolutely,
elections.
absolutely. The entire ballot, you must vote the entire ballot.
Yeah.
Yeah, and at its core too, you know, at risk means at risk at failing to be promoted to the next grade level and ultimately at risk of not graduating. And so the state has identified very specific characteristics of students, including those from low income backgrounds, those who are English learners, students with disabilities, Black students, you know, are also, you know, identified, you know, at risk. So not suggesting, you know, any deficit oriented, you know, language to this, you know, at risk, but that's what is recognized by the state.
And I'm trying to do all that I can, because Marcus knows and Corine knows that every Monday when I go into my office at the Raleigh Apex NAACP, I can anticipate 15 to maybe 30 letters from inmates. And I'm trying to do everything that I can to reduce that in our society. We have to reverse this cycle. And it all begins with those three things my grandmother, my great-great-grandmother used to talk to us about every morning when she'd wake us up and make us that oatmeal with bananas and brown sugar and stuff like that, and playing Mahalia Jackson in the background. And she wouldn't let us watch television because she said we had to do the 3 R's, read, write, and arithmetic. And so we got to get back to that basics of realizing that that's what this is about. We're developing children to become adults so they could be productive citizens in our society. And that's been our whole journey here in the United States. Trying to get there, one generation believing that the next generation is going to be able to do it better and faster. And we know what our opportunities and our capabilities are. We know we can sit here and put 1,000 books on a cell phone. That's our capability. Now, let's just make sure that we can educate the next generation so they can create the next new devices for the future.
I do see there's a question here in the chat. What is next around awareness for community advocates that are listening in or just in general? What do you think are some good next steps from all various vantage points? Let's start here, Gerald, and work our way down.
I always tell people, find your place in the movement. I tell people that there's that first group of people who are the helpers. They're the ones who do the little bitty things that mean a lot. They show up, they set the tables up, put the chairs up, take the trash out, pass out the water. That's the helpers. The next step are those people who advocate. They know the policies like Corine and David, and they know how to navigate the levers of politics and justice. Then that next step is the organizers like you, Marcus. You know how to take manpower and resources and make the best gumbo in North Carolina. And then there's people like me. I speak truth to power, but I teach people that you can't be effective at speaking truth to power until you help people, until you can organize them and advocate for them.
Well, for me, love has to be the foundation of everything we do. Love is an action word. You can't say you love someone, but there's nothing to show for it. And so for me, it's important that we come together to show love. For those of you who are anywhere near the Charlotte-Mecklenburg area, join the Charlotte-Mecklenburg NAACP and work with me. Because my style is this. I know that God has gifted each and every one of us for his glory and for his people. Bring your gift to the table. We are much stronger together. So let's work together to make sure that we are elevating the life of the people of the state of North Carolina.
I just recently had a millionaire join our branch here in Raleigh, and he said, I want to get in a fight.
I need to get 5 or 6 millionaires.
David, not calling you out as a millionaire, but calling you for your answer.
Yeah, definitely not a million. I don't know, honestly, these were really great answers, just thinking of the legal perspective, which isn't necessarily divorced from the love action, but how people can inject this into their own public races, both local, and statewide races. This needs to be a critical issue. And if people are going to continue to be electing people who don't believe in sound basic education for all children, don't believe in the promise of what educational equity can bring, not just to that student, not just to that community, but to the state, this has to be one of the central issues, that's at stake. And people from both sides, are going to have to come across and figure out, what solutions they're going to propose to this crisis, because it is a crisis. It's a crisis that's been hurting so many people. And you all know, because you all have been doing the advocacy. Other people, they send their kids to schools and that's all they care about, right? They live in their little bubbles and they don't realize, the impact that the denial of sound basic education has, on their community and on their state. And I think that really needs to be amplified as much as it can.
There is a lot that we can do just by letting folks know about Leandro. Even though we are growing a momentum through Every Child in Sea with dozens of organizations across the state, there's still that many more people, that many more organizations that don't know about Leandro. And I think every single day I'm reminded that we're so knee deep in this, that there are individuals that could be engaged and bring their gifts and talents if we just make sure to lift it up. This is the perfect time, the election cycle, to figure out where Leandro is on the ballot at every single level. Because all of these elected officers, from Supreme Court all the way to school board, have implications on education. We've mentioned the criminal justice system, and our sheriff's department is on the ballot. Our district attorneys are on the ballot. And so I think for those of us that are wondering what to do, go to these candidate forums and ask about school funding, ask about Leandro, and ask them, are they talking to their General Assembly members? The General Assembly is on the ballot this year. So there's a lot we can do leading up to early voting and election day, where if these individuals aren't supporting the interests of their constituents, then constituents have a right to choose and make that decision. So that's one of the things that I would suggest that we all do. And I see here, one question I want to make sure. We had Angus Thompson here this morning, and he had a chance to come in and bless the group before we officially started. And I think it's just amazing to see the generations of the fight. And that's what keeps me encouraged. Because if we would not have seen Angus before 94 doing what he is doing, if we wouldn't have seen Minister Mack doing what you have done to take, and the Charlotte-Mecklenburg branch to take as your leadership as president to the next level here, if we wouldn't have seen Matt do the work and Sarah and the Justice Center, Chris do the work, we would not be here today. And so I think that continuation of a fight is inherently American. It's inherently a part of our system to push the system to do better. We just don't always see the end result. Hopefully we're right here now where we can see the end result of this in our lifetime. And if not, we have the ability to change the course of who's in the General Assembly. who's in our state Supreme Court, and make sure that balance of power, that impartial balance of power exists in a very real way. What do you explain to parents today about what they heard? And how do you keep them engaged for a mom that is in the first week of school, second week of school, with students thinking about how this investment can help support the holistic child? What do we tell them about what we heard today?
I tell them to get engaged. I think that it's important. I know that it's really hard when you're working and trying to provide for your family, but it's so important that you become the first advocate for your children in some way. And I'll help guide you in what your gift is in that work. But I think it's so important that the parents begin to lift up their voices. They have to be heard. Their children need them to be involved in a deeper way. But before I leave this table, I have to say this. David, I want to thank you. Travis, Matt, Marcus, my beloved Marcus, my brother Gerald, and Sarah, and everyone else who's not in the room right now. Thank you. Because when we started in this particular struggle, we actually felt alone. And we've ended up now with a village of diverse people who love children, who understand the responsibility of justice, and understand that we're standing on very broad shoulders of those who came before us, many who sacrificed their lives to ensure that our children can have an equitable education. And this work is not in vain. It's not in vain. I have nothing but love for each and every one of you in this room. I want to thank you. And I know the fight has not ended, but what I do know is that we are going to win this fight. If not today, if not tomorrow, very soon, because of the fact that we are passionate and committed to the fight.
I encourage everybody to go and download your sample ballots. The sample ballots are available right now. Sit down, advocate for those who you want to see in office, and sit down with your family members, make sure they're educated on how to vote up and down the entire ballot. And if you need any help, you can always reach out to any of our NAACP organizations, and we can help you out with voter registration forms or anything else that you need. We've been able to make sure that we get everybody to the polls. It's not just registering them, you got to get them to participate too. And so as I always tell Marcus all the time when we're on the phone, it's not about passing the torch, it's about lighting them. And we all walk together and go through this together.
I'll just add that, you know, the status quo has got to go.
Amen.
It's not good for anybody in the state of North Carolina to have one of the worst public education systems in the country. No state should be fighting the rush to the bottom. And that's exactly what the state leaders are doing right now. Again, this is not a pie in the sky plan. You know, the comprehensive remedial plan includes very intentional, you know, structural foundation issues that have to be addressed to at least give students a chance, a fighting chance, you know, to succeed in school and in life. And parents need to understand that, you know, public education still is the greatest public good, you know, that we have. People keep on fighting against that. It's not a public good. It's not a public good. Yes, it is. And it's one of the greatest goods, you know, that we have to offer, you know, generations of students. But unless we want to continue this maleducation that our students have suffered, you know, over the past generations with just little glimpses of hope, right? You know, because North Carolina has done, you know, some great things. Its Teaching Fellows program from years ago was a model program from across the state. And it stopped investing as much, you know, in those programs. So, you know, we just need to keep pushing, and we need, you know, the average voter, you know, the average non-voter, you know, to try and help, you know, prioritize this so that we can get rid of the status quo, which is not good for any child, and it's not good for the state of North Carolina.
I want to thank folks that have been with us since our rally last week or this weekend, to the press conference today, to the prayer vigil hosted by Pastors for Children and Suzanne Miller, to all the different various entities that have helped support. We have to protest, we have to pray, we have to vote. I think those are the words from Angus Thompson on Saturday. Those are the words that I'm gonna end with today. And I want to thank everyone for your time, and let's keep moving. Make sure you stay connected to Every Child NC and make sure the state lives up to its mandate. And thank you all for the work that you're doing.
Thank
Shout out
you.
to my third grade, Wilson, what's going on?
Thank you all.